الحمد لله رب العالمين وأفضل الصلاة وأتم التسليم على سيدنا محمد وعلى آله وصحبه أجمعين. Assalamu alaikum wa rahmatullahi wa barakatuh. I would like first to welcome you all, brothers here at the masjid and the brothers and sisters who joined us on Zoom. On behalf of welcome all to our weekly session. On behalf of Islamic Centers and Grand Blanc Islamic Centers, I would like to welcome our distinguished speaker, Attorney Brother Abed Awad, who joined us from New Jersey. We're honored to have him with us tonight to discuss this important issue that concerns all of us. The topic of our lecture today is Fulfill Your Faith and Protect Your Family, Introduction to Sharia Compliant State Planning. Dear brother and sister, due to the nature of the lecture, we'll designate, inshallah, we expect many questions, so we designate more time for your question, inshallah. So whoever has questions, please raise your hand at the end. All questions will be answered, inshallah, in order. Before I move to our speaker, I would like to give a brief bio about our brother Abed Awad. Abed Awad is an attorney in New York and New Jersey. He's AV rated by Martindale and is a fellow of the International Academy of Matrimonial Lawyers. Mr. Awad was a professor at Rutgers University Law School from 2003 to 2020. Brother Awad is the founder of Sharia Wiz, an online portal for Muslim American state planning. He is a national expert in Islamic law and the laws of Muslim countries. He has published extensively in various publications, and he has more than 200 television and radio appearances as a political and/or legal commentator for numerous media outlets, including the New York Times, ABC, CNN, Canadian Broadcasting Corporation, Al Jazeera, the BBC, and NPR. I move now the talk to Brother Abed Awad to start his lecture. Go ahead, brother.
Thank you very much, brother, for that very kind introduction. Bismillah ar-Rahman ar-Rahim. Assalamu alaikum lil-jami' wa salatu wa salam ala as-sadiq al-amin. Today, I'll be able to speak both in Arabic and in English, but I'll do the presentation in English. And if anybody would want me to answer in Arabic, I can do that as well. I'm going to try to limit my presentation to 30 minutes and open this for a conversation amongst the participants. I will answer any questions related to estate planning or anything else related to Islamic law in America. So let's start with the Islamic inheritance system. I'm going to give you a brief introduction. This is going to be your like 101 elevator talk. So the Islamic law of inheritance is a mandatory intestacy inheritance system. What that means is that God has already decreed in Surah An-Nisa, as the Quran says, this is an apportionment from God. So you have limited availability to deviate from the Quranic mandatory inheritance system. So this means that the estate is going to be distributed as prescribed in the Quran. The Sharia divides, now when we talk Sharia, so for people to understand, I understand many of you are physicians and highly educated. So the Sharia is the Islamic epistemology par excellence. It's the methodology that produces knowledge for the Islamic civilization for 13 centuries. So as a system that produces the methodology and produces this knowledge, it is anchored in the message of the Quran and in the Sunnah of the Prophet Muhammad sallallahu alaihi wasallam. So the scholars who extrapolated the law and the methodology from the Quran and from the Sunnah divide the Islamic heirs into three groups or three categories. The first one is the Quranic heirs, Ahl al-Fara'id. And this one is very simple. It's what is listed in the Quran. So the Quran in Surah An-Nisa has a specific list of heirs who are going to receive a prescribed or predetermined share. It's either 1/2, 1/4, 1/8, 2/3, 1/3, or 1/6. This is in the Quran. 9 females, 4 males. As you can see, wife, daughter, son's daughter, mother, paternal grandmother, all the grandmothers, the sisters, and so forth. And the only people that receive a prescribed share that are males are husband, maternal brother, father, and maternal grandfather. Then the second category is the residuary heirs, which this means is after the obligatory folks receive their 1/2, their 1/4, their 1/6, their 1/8. Are you hearing me?
Yes.
Okay. So the residuary heirs are those who will take whatever's left. So let's say father's getting his 1/6, mother's getting 1/6, there's 2/3 left. Who will receive the 2/3? If there's no one in the prescribed shares, it's going to go by ta'sib. So you take by ta'sib. And taken by ta'sib, there's a hierarchy of those entitled to take by ta'sib. So nothing is left. You will have this ranked in order of priority. And it's a pretty sophisticated system. I'm just going to give you some simple examples. So for example, a son and a daughter will take the balance. So they're not receiving. The son and the daughter, when there's a son and a daughter.
السلام عليكم. الصوت غير مسموع. الصوت غير مسموع.
الصوت غير مسموع.
Sound is not heard.
I believe
صوت مسموع جيد.
So go ahead, brother.
It's probably on your side. We can hear it fine.
Okay.
I give
So,
you all of this, I give you.
So for example, you have a son and a daughter. They will take by ta'sib. مثل حظ الذكر أنثيين, double the share for the daughter. But if there are no children, then the siblings take the balance remaining. If there are no siblings, then the nephews take the balance remaining, and so forth. So it's a hierarchy. If there are no Quranic heirs, and there is no one to take by ta'sib, then it goes to Dhul Arham. And Dhul Arham is through the female line. This is a very rare circumstance for someone to have no one in his paternal line. Translations of Dhul Arham in English has been distant kindred, uterine heirs, or outer family. I'm going to talk about now the other legal tools, these jurisprudential, doctrinal tools that were used by the scholars. In fact, the science of algebra was born because of the fractions and the determinations of the mathematical formulas for the Islamic law of inheritance. So one of those concepts is called Rad. When the total prescribed shares do not exhaust the entire estate, there's going to be money left. That money has to be either increasing the shares proportionately, and you got to determine who is available. So this concept is a concept that's used by the scholars. And Rad literally means return to, and things will be utilized, whatever's left, proportionately to the remaining Quranic heirs. The other concept that we talked about, ta'sib, which basically means that it's going to be divided by those who are receiving the balance that's left. These concepts are used by the scholars. And an example of ta'sib is if the survivors are a mother and one son, the mother's prescribed share is 1/6. The son will take the balance by ta'sib. Another concept is awal. And in the awal concept, it's where the prescribed shares add up to more than 100%. So you have somebody receiving 1/2, somebody receiving 1/6, somebody receiving 1/3. So it is more than 100%. So the scholars created awal, and in the awal, it proportionately changes the fractions to make it be 100% and equal to everyone who's in the shares. What's an estate plan? So now I gave you this real brief introduction to Islamic law of inheritance. So you need to know that big picture because now you live in the United States. If you lived in Egypt, if you lived in Palestine, if you lived in Pakistan, if you lived in a Muslim country, you don't need to worry about the Islamic law of inheritance because it is an automatic system. You can't opt out of that system. But in the United States, if you want this system to apply, you need to opt in. You need to memorialize and write an estate plan, letting the court, letting your heirs, letting your family know that you want the distribution to be Sharia compliant. So I'm going to give you a basics now of what is the Sharia, the estate plan under American law. So we call it an estate plan because it's a plan. You're planning for your end of life. And a standard plan includes a will, a healthcare directive living will. I understand many of you are physicians, so you're familiar with the advanced healthcare directive, and a durable power of attorney. A will is not complicated or expensive. You don't need to be rich to have a will. Even if you have minimal assets, you want a will to ensure that your property is distributed according to your wishes. You select your burial wishes. You appoint your guardians for your kids. You pick who's going to handle the financial affairs after your death. And so much more can be contained in your will. Now, not all assets are going to be distributed through your will. Some assets will pass automatically to the surviving co-owner or the beneficiary named. Whether you have him in the will or you don't, it doesn't matter. And the will doesn't control. These assets include things like property you transfer to a living trust, life insurance proceeds. Life insurance goes directly to the beneficiary, unless you named your estate to be the beneficiary. Funds in your IRA and other retirement accounts, you have already designated who your beneficiary is going to be. Securities held in transfer on death accounts. So you can have an account to say, it's my account, but when I die, it goes to Muhammad or it goes to Fatima. So that gets transferred outside of your estate, outside of your will. Pay on death bank accounts. Real estate. So if you own a house with your wife, you may own it with the right of survivorship. So whichever spouse passes away first, his interest or her interest in the house passes to the survivor. Now, some of these issues have Sharia implications. You know, some would say that a right of survivorship constitutes inheritance, therefore it is prohibited. And you should change your ownership title and nature of your ownership to make it without the right of survivorship. A healthcare directive living will, you designate a person that you trust to make important healthcare decisions for you. You want somebody you want them to know that you're Muslim, you want them to follow your Islamic traditions. So this is very important, whether it comes to organ donations or whether it goes to brain death or whether it goes to, DNRs and so forth. All of this will be contained in a Islamic Sharia compliant living will. And finally, your power of attorney. If you're incapacitated, you're sick, you need somebody to help you. The power of attorney gives your agent the power to transact real estate, enter financial transactions, make legal decisions for you. This type of attorney, power of attorney, will terminate upon your death. So, if you're disabled in the hospital and you need your Social Security, or you have to go to work, or you have to go to a bank, or you got to go to your safe box, the power of attorney will help you in that case. So that's a comprehensive plan that we usually create for our clients in New York and in New Jersey. How about a trust? There's also what's called a trust-based estate plan. I just gave you the 3 components of a will-based estate plan. In a trust-based estate plan, you're going to have 4 documents. You're going to have a living revocable trust. You're going to have a pour over will. You're going to have the healthcare directive, and you're going to have the power of attorney. Now, I'll talk about the differences, but a revocable trust, it's a legal document that you create, and you're going to transfer title of ownership of your assets into the trust. You're going to appoint a trustee. Generally, you will be the trustee in your lifetime. And when you pass away, you have a successor trustee that will handle the distribution and the management of your affairs at your death. What is ironic here is that the concept of the trust is believed to have entered and become part of the common law system, the American and British legal system, through Islamic law. The trust is basically a waqf, and Muslims have created the waqf from the time of the Prophet ﷺ, and the scholars have developed a very sophisticated jurisprudence regarding the trust. Sometime in the 10th, 11th century, when the Muslims had lost control of Sicilia, of Sicily, the Normandies had come to Sicily and took over and defeated the Muslims. And the Muslims had developed a diwan and had a legal system, a legal court system. So the Normandies, they didn't dismantle it, they learned from it. And that's how this concept of the waqf had transferred to Europe. And in fact, the civil law system doesn't even have the concept generally, like in France and so forth, but the common law system has this concept. And we're going to talk about the waqf later. So what's the difference between a will and a trust? A will goes into effect only after you die. A trust becomes effective when you sign it. When you die, the will directs your executor to carry out everything. A trust, you will use a trustee to manage your assets during your lifetime and a successor trustee to distribute your assets after death. Why do you need an Islamic will? Because of all of the explanations I just explained to you earlier. You want to make sure that your assets are divided according to the Quran. You don't want a court to decide who gets your assets. You don't want a court to decide who cares for your children. You don't want a court to decide who manages your financial affairs. You don't want them to decide everything about your estate. You don't want a court to decide your burial rights. So there's so much that's at stake here, dying without an Islamic will. And also dying without an Islamic will, you also do not leave your legacy, whether it's a sadaqah jariyah, whether it's a legacy that you're leaving a message to your family that's important to you. What does the Islamic will cover? It covers everything a secular will does, but you get your burial rights, you distribute according to the Sharia, you select who you want to be your executor, you select a Muslim to be your guardian for your children. You put somebody you trust to manage your children's money. And most important, you leave money for charity. I mean, sadaqah jariyah is part and parcel of our act of worship. In fact, if you pay attention to the Quran, anywhere you see charity mentioned in the Quran, it's always combined with an act of worship. So charity is very important to our community. Is it obligatory to have an Islamic will? I've spoken to many Muslim scholars in the United States, and most imams and most scholars believe or take the position that it's obligatory to have an Islamic will when you live in the US, because otherwise you're not complying with your religious faith and with the traditions and restrictions that are in the Quran. So if you don't want the state law to decide who gets your assets, you could retain a local lawyer, or you can go to Sharia Wiz. So Sharia Wiz is a project that I launched a couple of years ago. It is an award-winning, the most sophisticated estate planning platform for Muslim Americans. So you can go do your own will at a fraction of the price as opposed to going to an attorney. but this is an option. So go to a lawyer in Michigan, get your estate plan prepared, or go to Sharia Wiz. Now, I'm going to tell you some Sharia Wiz Islamic will solutions, which you could utilize if you go on the Sharia Wiz platform and use it, or you can tell the lawyer that you're retaining in Michigan to take these into account. As you know, if you pass away and you have children, your wife is going to receive 1/8 under Islamic law. That violates state law. In most states like Michigan, a wife is going to have what's called an elective share, which may be up to 1/3 of her estate. I'm doing this lecture for educational purposes, just a disclaimer. I am a lawyer, but I'm not your lawyer. And this is educational. I'm not providing any legal advice. I'm giving you some legal and Islamic law educational materials and hope that this is going to help you. So what can we do for the 1/8? In many cases, what I've recommended to clients and what we do in Sharia Wiz is that we can give a life estate to the marital residence to the surviving spouse. So whether it's you, a male, or the wife or the husband, each of you give each other a life estate in the marital residence. That means that the house does not get sold until both pass away. This is Sharia compliant. The issue of al-manfa'a, mad al-haya, is accepted by many of our scholars in the pre-modern period. Increase to mahr. You may have been a medical student when you got married. You don't have a pot to piss in, and you gave your wife a mahr of, alif lira suri. So it means nothing right now. So you're now a successful surgeon in Michigan, and you're making $1.5 million, $2 million a year. You could increase your mahr voluntarily to be the marital residence, to $1 million, whatever it is. That's considered a debt. Like if you go to the Syrian personal status code, al-mahr al-mu'akhkhar al-sadaq is a preferential debt against the estate. Same thing in Palestine, same thing in Egypt, same thing in many countries. When a person dies, the first thing that's paid, any outstanding mahr is paid first, plus the wife will receive her 1/8. So if you increase your mu'akhkhar al-sadaq in your estate plan, your wife now is protected and it's Sharia compliant. Moral and religious debts. Now, when it comes to moral and religious debts, there's a position that you signed a marriage contract. We know that financial obligations are gender specific in the Sharia. You have to provide your wife with food, shelter, clothing, and many schools even say a domestic servant to help around the house and to do chores. So if you take that contract seriously and you want to comply with it, you probably owe your wife for a lot of money for all these years of services that she provided you. Most likely she provided you voluntarily and free, but you can say, I owe you that money. So you can provide a debt that you owe her. For all of this work that you provided, I owe you 50,000, I owe you 100,000. I want this to be paid as a debt against my estate. In fact, there's some places around the world, Muslims have argued that there's something called ujrat al-mithil. And by this theory of ujrat al-mithil, that it would compensate for all of the maintenance that wasn't paid during the marriage. Another argument on moral and religious rights is that, and this is in the Maliki school, there's a legal cause of action called al-kad was-si'ayah. So what happens is that your wife gets up in the morning and she goes to the store and works with you. She pools her money with you. She goes to the farm and gathers the fruits and sells them with you. So she's participating in the acquisition of these assets during the marriage. So this is called a marital acquisition that she has a claim to. She has a legal and moral claim. So you can acknowledge that your wife's contributions and give her half of the assets, 25% of the assets, And this would be a debt against your estate that will be set aside in addition to her receiving her 1/8 assets. Other things that we do on the Sharia Wiz platform, we do address huquq Allah, like Hajj, Zakat, and Kafarat, and Nizr. These are things we do include in our Islamic wills. Finally, the 1/3 of your estate, you are permitted to provide bequests to members of your family or friends and so forth. But the Sunni position, la wasiyya liwarith, the bequest cannot be to someone who is going to already receive something by the Sharia inheritance rules. So for example, your daughter is going to receive a share, you can't give her extra. You can't give your wife extra. But if your brother is not going to be taking, in other words, you have a son, so your son blocks your brother or blocks your sister, you could leave him up to 1/3 of your estate, and you can leave up to 1/3 for charity. What about an Islamic trust? So Sharia Wiz offers an Islamic trust with the same Sharia compliant solutions in the Islamic will. And this model of the trust I worked on with scholars at Azad. Azad is a very large asset management company, Sharia compliant in the US. I worked with them to create this model to help people, Muslims around the country. The Islamic trust also avoids probate. There's no court. Everything is done privately. Now, the big issue is the most important, which I think many of you should take advantage of this structure and this model, which is al-waqf al-ahli, al-waqf al-dharri. So most of you know about the waqf al-khayri. We all do waqfs for charitable giving. But the Muslim scholars also created al-waqf al-ahli, meaning that you could also create a waqf to benefit your wife and your children in the next generations. And I worked very hard, and Muslims utilize the family waqf for estate planning for 1,000 years. And Muslims have forgot all about this sophisticated estate planning tool. And I have been working to bring this back to estate planning in the American Muslim community. Like I said, I collaborated with Azad. They're a premier Sharia compliant investment company. And we wanted to develop a family trust, waqf ahli, that's valid under American law, but most importantly is faith compliant with being Muslim and compliant with the Quran. So how does it work? The Islamic family waqf is essentially a Sharia compliant joint trust for married couples. The married couple agreed to transfer both of their assets, their separate and their joint property, into the family waqf. After the first spouse passes, his or her assets are kept and preserved in the family waqf. There is no distribution. The surviving spouse manages them. After both spouses pass, their respective assets are distributed to their respective Islamic heirs at the time of death. So this preserves the marital estate for families as opposed to disturbing them and fragmenting them after one spouse passes away. So that summarizes my presentation. And now I leave the floor to answer any questions that you have about what I said or anything related to estate plan. Thank you.
Jazakallah khair, brother. We'll open up for questions. Go ahead, Dr. Jamal. Yeah, Dr. Jamal, go ahead.
Assalamu alaikum.
Wa alaikum assalam.
You said that la wasiyata liwarith. You don't have a for people who are like your wife, by giving a, like what you said, increased mahar or debt, or isn't that the tahayul around wasiyata liwarith? I mean, she is, according to Islamic law, she take 1/8. So by doing those extra things you mentioned, you make it like 1/3 or 1/2. Isn't that fuqah wise? I mean, Sharia wise is not.
No, absolutely not. It's not the tahayul, because those tools are things she earned. In my lifetime, I can transfer all my assets and give it to my wife. In my lifetime, I have to look at all of the surrounding financial circumstances. The Sharia is a living tradition. It's a methodology. It's not about black and white. And to comply with US law, you have an issue. And number two, you and your spouse, you know your financial circumstances. You owe her. She did this for you. You are voluntarily doing this. This is not the hayy. This is you acknowledging the financial and non-financial contributions of your spouse, and you're doing it. If you would have gotten married when you were a successful physician, probably your mu'akhar would not be alif lira suri. It could be, $1 million. The waqf could have required you to purchase a home or certain financial circumstances. So this is relating to financial circumstances when it comes to mahr. When it comes to the two other parts, those are rights she acquired. She went to your medical practices and been dealing with it. She's been your manager. She's been your bookkeeper. She's the one who's managing maybe the real estate development. So what you're acknowledging is something haqq laha. Mish ishi sadaqa. She earned it. And the same thing as it pertains to the issue of the marriage contract. The marriage contract says you're supposed to provide food, shelter, clothing, and a domestic servant to help her. So all you're doing is acknowledging a debt that you feel you owe her. So in my opinion, it is not the hayy.
Can I speak?
Go ahead,
I have a question. I have a question.
There are people before you.
I have a question.
Go ahead, Bob.
I have.
But at the back,
Aywa. I think
Right,
it is
right.
subjective. What the brother said is subjective. It's still tahayul. If he believes that she deserves it, why he didn't give it in his life and give it to her as a gift or whatever? But as long as she get it after he die, it is tahayul, still tahayul, like part of wasiyah. What the wasiyah is you designate some money to somebody after you die. So why, if he believes that she deserved more than what she had in her, designated mahar, why he didn't give her in his life and get done with it?
Number one, he is giving it. He's acknowledging the debt. So
Acknowledging, not giving.
This is a debt.
Brother, your lawyer is acknowledging different than giving. Acknowledging, I agree, but he's not giving it to her in his life when he kept it. After he died, become wasiyah.
No, it does not. And with all due
This is your
respect,
opinion. This is your opinion, but this is subjective
but
opinion.
still,
You have no base for it.
no, I do have a base. All of this
I don't think so.
This has been happening you will find it in the fiqh books. This is not new. Number one, for your information, because you're saying, give it to him. Tabana, I owe my wife for all of the things she did for me. And the only thing I have is my house. Do I go sell my house to pay her? Or acknowledge a debt to put a lien on the house so she gets paid when I die? It's the same thing. It's a debt.
Same thing. This doesn't explain or they give a legitimate reason to make it after you die to give it to her. Still, it is wasiyah.
Sure. So Ahmed, when you do your will, you don't include it. This is not obligated on you. If it's your interpretation and you're subjective and you believe that it's a wasiyah, then you just give your wife the 1/8 or give her something in your lifetime.
Let me make that question more simple.
There are two other questions.
What the difference between wasiyah and what are you saying? If you keep rights, whatever you like.
Because a wasiyah is mirad and the other one is a debt.
What are
It's
you
a
make
debt.
it that? You call it that. It's not this. It's the wasiyah too.
But it is a debt. And we're telling you,
Okay,
think it's not
fine.
a debt. So
that
it's up to you. You're free. You feel it's not a debt.
Can we allow more questions?
Dr. Hisham Jayyar, go ahead, brother. Hisham Jayyar,
I have a hand raised, brother. Hand raised.
go ahead, Dr. Hisham.
I have a hand raised too. Yes.
Yeah, go ahead.
I have a question.
Go ahead.
Yes, Assalamu alaikum. Jazakallah khair, brother. And with respect to the topics and and so on. I have a question about the inheritance law, and it was not addressed in the discussion. People that live in the US are subject to estate law and estate planning and the estate taxes for those that would inherit at certain limits. And when that gets complicated, is that addressed in the wasiya and the website you mentioned? Or does
No,
it need...
again, if your estate is complex, meaning it's your assets are over 6-7 million, you definitely need to talk to a lawyer, because there may be things that you have to do in way of estate planning. Now, currently, the estate tax, the deduction is 12 million a person. So it's 24 million. So unless your estate is over 24 million, you're kind of safe from a federal estate tax exposure. But there are a few states that have an inheritance tax. I think there are only 4 states. I don't believe that Michigan does. I don't know what Michigan's estate tax is. So that's one thing, we can research and look into.
Excuse me, brother.
Yeah.
Michigan has no estate, no tax on inheritance. I know that for sure.
Perfect. So in that case, like I said, your only exposure is the federal, and you have to be over 24 million. In many states, like in New Jersey, it does have an inheritance tax, but it doesn't apply to first class, like children, spouses, and so forth. It may apply to siblings. But if Michigan doesn't have an inheritance tax, then the only thing you got to look at is the federal estate tax.
I raise my hand, brother.
Samir Basafa.
Assalamu alaikum. Assalamu alaikum wa rahmatullah. Quick question about the family trust al-waqf.
Yes.
Two prong question. Number one, is there scholars fixed opinion like majority or jumhur that this is lawful in Islam?
Yes, al-waqf al-ahli has been in operation for 1,000 years. You have the only country is Egypt. After the revolution, they canceled and repealed al-waqf al-ahli statute. But when you go to other Muslim countries, there is a statute, there is a law for al-waqf al-ahli. So it's legitimate. Now, there could be differing views on whether you need to include some charitable component. There could be rules on whether how it could be established and when it will end, that it can't end, it has to be permanent. There's some various opinions, but our scholars, we had the Sharia board at Azad, asset management, had reviewed it and approved it. So yes, the thing is what I have to understand from all of you, that please bear with me. The Sharia is not one answer. The reason we had multiple schools, and the reason is that the Sharia tahtafi bil ikhtilaf. It celebrates difference. So there's going to be different opinions.
Okay, just to follow up, I think this is very interesting to know, but I'm suggesting to myself and others, when the time comes to form that waqf, to consult with local alim, sheikh, not only in just general Islam, specifically in the Sharia wal Iqtisad, to make sure it's done properly, number one. Number two, my second part of the question is, I'm recommending, and I'd like you to expand on that, when this is thought of and is going to be done, please have all the beneficiaries, your children, be involved with it from the beginning and be part of the approval of it. The thing we need to avoid is major clash or problem between the spouse and the children, which has happened, of course, in the past. If it's done earlier, proactively, and this is with the knowledge and approval of all the children and the spouse, that this money does belong eventually to them. You are keeping it here to protect the wife, the spouse initially, because usually mostly the children, let's say they are married or they have a family and so on, unless you have minors. And minors, I think, they should be kept at a separate category in the family waqf. I think this is extremely important with what you mentioned about
But
a
all of this
trustee.
is covered in our waqf. Everything
Yeah,
we're
but
saying
I'm saying it
covered in
should
our
be,
waqf.
I'm sure it is, brother, but
Mm.
you have it written somewhere. And I'd like to take a few moments, please, to tell us how it is important and advisable and critical to have the children and the wife all sit down and accepting it and approve it, and preferably either sign
Again,
or make some
Azizi,
acknowledgement,
it's
please.
going to
Thank you.
depend on your family circumstances. You know, if
I'm talking about
you
in
have
general,
adult
in general.
children and you want to involve them is one thing. If you have a wife that is not the mother of your children, that's a different factual circumstance. Everything is factually specific. I'm not
Sure.
going to sit down with my kids. I'm close with my wife. I know what I want. I know what I want to happen to my children. I'm doing what my wishes are. And my wishes is to comply within this moral framework, and that's what I'm going to do. So what you're asking is something that every person is going to be different. What you suggest applies in many circumstances, but not in every circumstance. So yes, having this conversation with your family is very important. And
Thank
then
you.
you're technically complying with your faith. So
Thank you. Thank you very much.
Dr. Samir, just because we need to give other also a chance to ask. Brother Abdul Hakim, go ahead.
السلام عليكم. جزاكم الله
Salam.
خير. ما شاء الله. Question, brother Awad. You mentioned about the exemption for the marital exemption, 12 million. 2023 is actually close to 13 million. And for a married couple, almost 26 million. Now, you may want to also introduce the idea of a gift tax that could be also passed to the children at their, or to the family while you're still living, and at the same time reducing your taxes. How does that work with the estate planning, and is there a provision on it in part of the Islamic trust you're referring to?
no, I mean, these are different tools. And like you said, unless your estate is very high, you don't have too much exposure on the estate tax. Giving your children gifts also come in within that marital exemption. That's something you would discuss with your financial advisor. You would discuss that with your accountant. I'm providing the basic estate planning. I'm not advising people specifically on, gift taxes and things of that nature, but that's an important point that you raise. And, if we want an advanced presentation, we can do a presentation that is very strictly based on the tax issues.
Okay. Jazakallah khair.
Dr. Amin.
Assalamu alaikum. Jazakallah khair. About the trust, so basically you give the right to distribute your wealth to the successor trustee. And so, I mean, you trust them, of course, but it's up to them to distribute it in Sharia law or not?
No, it's not up to them. It's not up to them. What happens in the family waqf that we utilize on the platform and that we utilize in our practice, there are two schedules. There's a schedule of assets for the husband. There's a schedule of assets for the wife. If you die first, your schedule as the husband stays in the waqf, earning money, being managed by the wife, but with the objective of preserving it for the Islamic heirs. So when she passes away, yours are distributed to your Islamic heirs at the time of your death. If any of them have passed away, it goes to their heirs. And the wife's assets will be distributed to her Islamic heirs. If there's a remarriage, there's a termination and then a distribution immediately. Otherwise, see, the thing is, what you have to understand, you guys are doctors mostly, from what I understood, and businessmen. You're married for 20 years, you have a business, you have all this money. You pass away, everything is going to get distributed. Everything gets fragmented. Your kids get what their shares are. And then that's where there's some problems. When we represent non-Muslims, every non-Muslim couple that we represent in my firm and most of my colleagues, they do a joint trust and they leave everything to their spouse under her control and then goes to the kids. Because you don't want to fragment and divide the estate after one person passes away. So Muslims did this by using the family wealth. You have that option. And again, I want to emphasize, al-fiqh was defined as ilm al-ikhtilaf, the science of difference. We don't have to agree on the fiqh, we don't have to agree on the interpretation. None of this is binding on you. It is up to you to decide what you wish. You want your house and everything to be sold and distributed, and you want all of the beneficiaries to figure out how to divide it when you die, that's fine. If you want to keep it together for at least until the surviving spouse passes, then you could do the waqf setting. If you don't, you could do just a regular individual waqf, which terminates when you die.
Dr. Khalid Shukairi, go ahead.
Jazakumullah khairan. Two questions. Number one is in regard to the will. If we state in the will that my wealth needs to be or asking to be distributed according to the Islamic law, just these few words, that's enough in the will?
No, that is not enough. That will not be enforceable. Over 20 states have anti-Sharia legislation. Not only do we have the anti-Sharia legislation as an issue, but we also have the separation of state and church. A Michigan state judge cannot interpret and determine what is the Islamic law of inheritance. What we do in our practice and what Sharia Wiz does as a format, we have a proprietary Islamic inheritance calculator. If you go to shariawiz.com, you will be able to find, you know what I'm gonna do? I'm gonna put this in the chat to everybody. If you go to shariawiz.com, you can answer a few questions and it'll tell you what the Islamic inheritance distribution is. What are the fractions? Our will populates those fractions in the will. This is how much mom gets, how much dad gets, how much wife gets, how much son gets. And then we also say, if any of these people predeceases, my executor or my trustee is to recalculate according to the Islamic inheritance appendix, which is part of my Islamic will. So no court has to determine or interpret Islamic law. So this is the guarantee of the enforceability of your will to avoid any court issues about the Sharia.
The second part of the question is establishing trust in Michigan. Is it different than in New Jersey's or other states?
There are very minimal differences. The Sharia Wiz platform is state specific. So there is what's called the Uniform Trust Act. Most states have incorporated that statute for their trusts. The main differences are signature differences and acknowledgement differences, some formality differences. All of these have been taken into account on the Sharia Wiz platform.
Jazakallah khairan.
Well, Abdul Rahman Zanabi, go ahead.
No, there's a chat question for a long time.
Go ahead.
Brother Al-Munajjid had a question. When we use this site, do we need to certify the will or need witnesses? Is it applicable in Michigan?
Of course. I mean, what you do is if you do a will or a trust, you're going to receive instructions on validating your will. Will require 2 witnesses, and some will notarization. All of that, all of those state-specific requirements are included in your instructions.
Dr. Abudan, go ahead.
Assalamu alaikum, brother. Jazakallah khair. As you see, the topic is out of extreme importance to the community here, given the nature of the Sharia law and the relationship to the American law. My question has 2 prongs. The first one is, does it have to be joint trust? Can a spouse go and make a trust for himself and then the other spouse go and make a trust for herself? That's the first question. The second question is, specifically, do you know any taxes implication for the trust? When you transfer in an asset, money asset, property asset, office, house, something to a trust holder, would that change the taxes or does it have any taxes implication on it?
For your first one, yes, you can do individual trusts, but keep in mind, in the Sharia Wiz platform, every individual trust that is following the Sharia and every individual will also include a community property agreement if you're in a community property state, or a waiver of elective share agreement if you're like in Michigan. So your wife has to sign off that she's accepting her 1/8 and waiving her rights to Michigan inheritance. So every one of our platform, every one of our templates includes this particular waiver. So if you do the individual trust, if you're going to do the 1/8, you're going to have the waiver issue that will come in. And you could do it, it's normal, and you avoid probate, and it's good practice. As it pertains on transferring assets into the trust, primarily in most jurisdictions, there is no taxable event. There may be, and this is something we have, the state specific, there may be a real estate transfer tax, a nominal fee that is required in some states when you transfer it to the trust. But that's a cost that you have to incur. It's not about taxes, it's about a real estate transfer, a one-time payment. In New York, New Jersey, in most states that I've seen, it doesn't have any such thing. You are permitted to transfer your house deed, any deed into a trust. It's very easy to transfer the membership interest in an LLC or shares in a corporation to the trust. Those are also not taxable events, because when you have a trust, it's your social security. It's a living revocable trust. So nothing really changes.
Dr. Harstani.
Harstani first and then.
Go ahead.
Assalamu alaikum, jazakallah khair.
Alaikum
I started the process a while ago, but then I stopped at the funding of the trust, so I couldn't really get the idea how do you fund the trust, so you have to, I assume like you have to transfer all or at least the registration of the real estate and the banking account to that trust. Is it the way to do it?
Yes. So what happens with again, if you retain a lawyer, the lawyer will help you in the process. If you go and do it on Sharia Wiz, you get an entire manual called the funding guide. And that provides you with all the information on how to transfer every type of property, from real estate to bank accounts to LLCs to corporations with form language.
Jazakallah khair.
Well, Dr. Farhan, go ahead.
Yeah, two questions. We know that the Waqf al-Khayri can be no more than 1/3 of your assets. Now, al-Waqf al-Ahli, is it part of that third, or what percentage?
No, there is no limit. Al-Waqf al-Khayri is giving for charity. Al-Waqf al-Ahli is you're putting all of your assets, and the charity is your children. So you're not restricted.
But it doesn't have to do nothing with the 1/3.
Nope.
Whatever you want.
Whatever you want to put in it. And in our case, in the US, people put all of their assets. Otherwise, it doesn't make any sense. So what you could do, if you were only going to put 1/3, that means you're still going to probate, and it still means that you're distributing all of your assets after one person dies. The objective is to preserve it, because if you do it on Sharia Wiz, you preserve it until the surviving wife dies. If you come to a lawyer and you want to do something more custom, more sophisticated, like I'm doing one right now for a client, it doesn't terminate when the surviving wife dies. It continues. So we create dynasty trust. So the money stays in the trust, you die, It stays until the wife dies. Wife dies, nothing changes. You have a successor trustee, the money stays in the waqf, and the manfa'a, the profit, the income, goes to the beneficiaries as you wish.
A second quick question. If you have assets in another country, Jordan, Palestine, and you create them a will or a trust here, you don't have to include whatever is overseas because it will be distributed.
No, overseas, Palestine and Jordan, قانون الأحوال الشخصية governs. You don't have options. It's already the land and things that you have there are going to be distributed according to the Islamic inheritance in Palestine and Jordan. Unless you go and you create a trust, you create a waqf in Jordan or a waqf in Palestine to hold those properties. This covers only your American assets, whether in Texas, whether in Michigan, whether in New York, it's covered. Now, when you own property in England, if you own property in Spain, we would have to talk with local council in those countries to make sure that they allow a foreign trust to own the asset.
Dr. Mazen Najjar, go ahead.
السلام عليكم. والله سؤالي كان نفس سؤال الأخ فرحان about يعني الأملاك خارج أمريكا، بس كمان يعني شغلة ثانية مادة الشغل شوي يعني صراحة معقدة، فممكن ولو على السريع مثلا ولو يعني نصيحة جنرال يعني رأيك إنه يعني إيش لازم نساوي يعني كفيزيشن يعني in particular in general, yeah, what's your advice to do
again,
in simple terms?
In simple terms, the problem is every case is different. If you're a physician, depending on how high of a level of income you have and how much assets, we may be concerned that we have to do asset protection. So if we're doing asset protection, all of a sudden there's going to be Sharia compliant issues because now you're creating irrevocable trust, you're creating, different LLCs and companies. If you have none of these issues, it's straightforward. It's highly recommended to do the trust because you avoid probate. You take care of everything in your lifetime. There's going to be no fighting. There's going to be no lawyers, no litigation. Everything is sorted out and cleared in your lifetime. So a family waqf is the best setting for the vast majority of middle class folks. That's what most of them select. If you have a good amount of money and you want to create security for the next generation, you could do the family waqf when you die. It continues for the next 100 years.
Jazakallah khair. Dr. Razzaq Ibrahim, Razzaq, go ahead.
Just for clarification on the family trust thing. So if you do set something up like that, would it not be distributed until the wife passes away? And if that is the case,
unless you have some specific parts of it. Yeah.
If that is the case, is that Sharia compliant? Sorry, I don't know very much about this stuff.
Yeah. Again, our scholar has held that it is Sharia compliant because it's being held in a trust, and that the trust is being preserved for the benefit of those Islamic heirs when she passes away.
Allah yajzik khair.
Dr. Awad, go ahead.
Got one more question about the dynasty trust. Is the dynasty trust considered Sharia compliant? That's number one. Number two, can you extend the dynasty trust for generations with specific purpose?
Yes, dynasty trusts are Sharia compliant. That's what the Waqf al-Dharri is. I was just looking at a Waqf al-Dharri for a friend of mine. It was established in 1827 in Nablus, Palestine, and it's still functioning now. So this is something that Muslims have created from time immemorial. So it is Sharia compliant. In fact, are not restricted to the same percentages. So for example, you can give your daughters equal. Doesn't have to be مثل حظ الذكر أنثيين. لأنه this is المنفعة that you're distributing, not the principle. Also, you have, let's say you have a child who's dedicated his career to science and to study, and he's not going to have much money. You can have him get a little bit more money because he's dedicated to education. You can put whatever restrictions and things that you want to go on for generations to generations.
Jazakallah khair. Brother Bakri Kaki, go ahead.
Assalamu alaikum. Could you please elaborate a little more on the asset protection and its contradiction with the Sharia compliance?
I mean, basically, the contradiction is if it's a debt that you owe somebody and you're just trying to avoid paying it. So, I mean, that's technically not halal. So, I mean, you know, you're being sued. You mean, why are you doing asset protection? Because you're afraid a patient is going to sue you and get a judgment against you. Or the situation is not working out and you're going to default on, you know, on an MRI machine that you have at your center so that you don't pay for it. So it becomes a problem. But people do it. You know, people have a way to explain it and do it. And sometimes it makes sense.
So my follow-up question. So you are a physician, you have, you know, a couple of LLC, and, you know, you have some assets in each of these LLCs. Does the website, the Sharia Wiz and the family trust cover all of these, or do you need to have an estate trust lawyer here? And
for asset protection, you need to get a lawyer. And that's going to cost you probably on the minimum 10 up to 50,000. Asset protection is complicated and there's a lot of work that goes into it. So the platform does not, no living revocable trust provides any asset protection. A living revocable trust you could cancel at any time in your lifetime. So it's, you act with your social security. So it's not an asset protection tool. Asset protection tools include irrevocable trust, transferring everything you own maybe to your wife, creating LLCs that your children own. You're taking everything basically out of your individual name and put it in other people's names.
So if I have a lawyer, a non-Muslim lawyer who's doing that for me, how do I include the Sharia with, say, family waqf that I established?
Well, you could reach out to me. I can co-counsel the estate planning with him. I mean, I'm a New York and New Jersey lawyer, but I'm an expert on this. So usually lawyers hire me and we work together to create it.
Okay, that's very helpful. Thank you. Jazakallah khair.
No problem.
But I have a question.
Jazakallah khair.
Next, inshallah.
So basically,
Brother
for the
Obara,
basic,
can I ask a question?
Yeah, next, inshallah. Dr. Hamoud will ask first, inshallah.
for the basic wealth and the trust, the website, the Sharia, what you have, you don't need to be notarized, no witnesses, and you can do it. And do you have to have a lawyer involved?
No, you still, the platform creates the documents. You follow the instructions to validate them. You got to bring the witnesses and you got to notarize. You don't have to take it to a lawyer, but you're free. If you wanted a lawyer to review it for you, you can do that, but you don't have to.
Dr. Basata, go ahead.
Yes, thank you very much. Another comment quickly. Mashallah, brother, make it very clear that although he's a lawyer, he's not giving legal advice today. And this is very smart and very accurate, and I appreciate that. On the same hand, I think it should be made clear that the brother is not making, he's not sheikh, he's not making fatwa that is solid and irrevocable. And I think we should take his word as an idea, and we should really elaborate on it with other scholars, because this is deen, and it is our responsibility, each individual, to make istifta. The brother, he had a comment, he had idea, he had researched it. I'm sure he spent hours and months and so on, and I appreciate that. But I think each individual should look into the idea with other Muslim scholars that we trust, run it by them, let them tell us what their opinion, and thank you very much.
Just
They've asked me a question. They've asked me a very
I'm sorry, let me respond to the comment, please.
Go ahead.
أبو البراء ولا اللي أحكى. I taught Islamic law for 17 years at I'm not a sheikh, I'm not an imam, but I've taught Islamic law for 17 years. In my own collection, I have 500 Islamic Muslim manuscripts written by hand. I've dedicated 20 years of my life working in this space. Everything that I said has been approved by scholars. It may not be approved by your scholar, but we have Dr. Mish'al, Abdul Bari Mish'al approved our Islamic trust and has approved our Islamic will as Sharia compliant and gave us a certificate. The Sharia board of Azad that has $1.2 billion under management, their Sharia board approved the family waqf that we prepared. So it is true, I'm not a sheikh or imam, but I do have a lot of experience and I've researched this extremely well. Others can have different opinions and you're free to go and get consultation, and maybe you will come with the same opinion or maybe with a different opinion.
Yes, Jazakallah khair. I have a question here. They've asked me a question, actually, a very important one. The one who sent the question says, I have a mother and a father overseas, and I want to leave them because they are ashab furud, 1/6 of each in my will. How can they get their shares from here, even though they live outside? They live overseas.
Good question.
Very easy. You pick the executor that you're going to trust, because that executor is to fulfill and implement your wishes. And your wishes is to distribute the 1/3 to your parents. So it'll be his responsibility to liquidate and send that to the rightful heirs. Adi. Normal, happens all the time. I'm doing as a state right now. Somebody in Egypt is entitled to some money. So I'm handling it and I'm going to send the money to the Egyptian family.
Jazakallah khair. Dr. Hamoud.
Jazakallah khair, Brother Awad. Your presentation is excellent. MashaAllah, your knowledge, you can very, very beneficial. I have a question for you, since you have such a great background in the study those issues, because every community have these problems. When divorce happen, and I know this is not related, when there's hardship, problems, then the man insists, I want to go by Sharia, get your mahar, and you have nothing else. And this, the American law is half, and it's in my, a lot of people think like, you're a doctor, you live in a $2 million house, and now you go on your own, rent in a small apartment for $500 a month, and your dowry is $5,000. People think it's not fair. They go to the lawyer, and people start pointing finger. Look, they left the Sharia, and now they are going after a Yahudi lawyer, etc. What do you think about? I'm sure you have those issues. What is your opinion about this?
I am the national expert on Islamic family law. I have testified more than 60 times and qualified as an expert in American courts. I've provided expert testimony on these issues to British courts. I've actually testified in Michigan courts. I come in lecture and done lectures to Michigan judges on the Islamic marriage contract. The Islamic marriage contract is not a prenuptial agreement. And the mu'akhar al-sadaq is not all that the wife will receive. She will receive all of her rights under state law. Very few states, actually any state, will find that the Muslim marriage contract for a doctor making 2 million and a mu'akhar sadaq 50,000 would be contrary to public policy. يخالف النظام العام. So it will not be recognized. Now, I am working on a
point of view. What does the Sharia and the scholars say about this?
Now, the rights that you have in the US, which are equitable distribution, meaning all assets acquired during the marriage should be equitably distributed, and the right to post-divorce alimony. These are the two most important components of the financial rights a divorced wife has under Michigan law. These two theories do not exist under the current Islamic family law in Muslim countries. So how can you waive those rights that you didn't have under Islamic law to begin with? So for those reasons, the opinions from many imams and so forth is that the mu'akhar al-sadaq is one thing, but the other financial rights are going to be default state rights, and you don't have a way around it. Now, I'm working on a project, and I have clients. I do prenuptial agreements, but I do prenuptial agreements that are Sharia compliant. We will include in the prenuptial agreement that she will receive 1/8 in inheritance. We will include in the prenuptial agreement that she will get some money for support. We cover everything, and everybody is aware and knowledgeable of what rights they are having under US law and under Islamic law at the same time. That's enforceable as a prenup. But a one-page Muslim marriage contract is not a prenuptial agreement.
Jazakallah khair. Dr. Khurfan, go ahead, Dr. Umar Khurfan.
Assalamu alaikum wa rahmatullahi wa barakatuh. You may have touched on this, but from what I know in Michigan, having a will, an Islamic will, is not technically binding. Is that correct?
No, it is binding, but it depends on what's contained in it. If you say, when I die, I want my estate to be distributed according to Islamic law, that's not going to work. That's not going to be binding. It's not a matter of it being binding. It's just that the court does not have the authority from our constitutional perspective to interpret what Islamic law is. If you say, I want my will to follow Islamic law, and here's what the Islamic law says about distribution. My wife is getting this much, my husband, my daughter is getting this much, my son's getting this much, my brother's getting this much. You specified that. That is binding and enforceable.
What about when it comes if both husband and wife pass away, when it comes to custody of children? Is that included in a will, and is that binding also or no?
Yes. If you and your spouse, because we include this in all of our state plans, we put, who do you want to be the guardian? I want Khalti Muhammadiyya to be the guardian. If both of you pass away, Khalti Muhammadiyya is the guardian, and that's what it's going to apply, unless there's some crazy thing that Khalti is on drugs or she's a bad influencer is going to beat up the kids. Now, if one passes away, it's going to go to the other surviving parent. But if you're separated, like I'm doing one right now for somebody who's separated, she is doing her will. Father has not seen the kid for 5 years. So her sister is the one involved with her child. So we're putting her sister to be the guardian. Now, the husband, the father, can come and contest the guardianship. But because he hasn't been involved and the sister has been involved with the child, we say there's an extraordinary event that occurred, making this sister have a psychological bond like a parent. Therefore, the judge, 9 out of 10, is going to leave the child with the sister and not give it to the father.
I'll take the last question. Brother Abdul Rahman Zanabi, go ahead.
يعطيك العافية. Very informative lecture.
Thank you.
Regarding the retirement accounts, 401k, cash balance plan, and things like that, and when you assign beneficiaries, is this considered part of wasiyah? Is it a gift? Should you put only the spouse, or you should be putting, percentages of the kids and so on? How do you do that with your investment bank?
Those are designated beneficiaries. Now let's talk about Egypt, Saudi Arabia, and many of these countries. They do not consider a taqa'ud miraf. So in Egypt or in Saudi, you pass away and you had a taqa'ud, it's going to your wife and kids. They don't consider it a miraf. Now, is a cash balance account going to be considered wasiyah, 401k, because you're contributing during your lifetime? That's really going to be up to the level of your tolerance on the ijtihad on it. If you want to be very, very strict, it may be considered improper, and you should just put the percentages of who's going to receive under your Islamic will. Do not name the will the estate. It's better to have the specific beneficiaries listed. That's an option. So it's really, there's no definitive 100% answer on this issue. I'm just giving you by analogy. التقاعد في أكثر الدول العربية لا يعتبر ميراث.
Brother, in the US, taqa'ud, the retirement, is like some kind of saving. Really, people do it for tax protection. It's a saving. Just like, instead of being in the money market account, you have it in the 401k to protect yourself from taxes. So why is it not so straight? I mean, I don't see why. It should be like part of the wasiyah. I'm talking about here, I'm talking about the US. Because it's kind of saving, it's not really.
But what we're saying, I understand. So what you're saying, if it's going to be part of the wasiyah, it'll be limited to 1/3. ولا وصية لوارث.
Right.
So that's one thing. But in my opinion, it's not a wasiyah. So it could either be direct beneficiary to the wife and to the kids, or it should be distributed according to the Islamic inheritance shares. Yani, let's say my survivors are my wife and my son and my daughter. So I would put 1/8 for my wife, 7/8 going to my 2 children. That would be the designated beneficiary distribution of the retirement account. However, you're going to have some tax implications, tax brackets. So there's like a lot of other variables that you got to take into account in this planning. So that's also a struggle and a tension when we're trying to balance being compliant with Islamic law and at the same time not opening ourselves up to hundreds of thousands and tens of thousands of tax exposure by complying with the Sharia.
Question, please.
Brothers, I mean, inshallah, we
One question? Can I have one last question?
Inshallah, next time, I mean, we have many demands from the brothers. We have another session, inshallah, if your time allows in the future, Brother Ali.
Inshallah. Thank you very much for hosting. Inshallah, we'll stay engaged. I put my name and phone number and email in the chat. I'm happy to answer any questions. You guys can reach out to me.
Allah yabarik fik. Jazakallah khair.
Assalamu alaikum.
Assalamu alaikum. Allah yabarik.
Expensive. لا لا يعني I think